in an advisory opinion. And she reminded both parties not only of their substantive obligations under international law, but also of the procedural obligation to move forward simultaneously. The United Kingdom's position on the principles for the implementation of Resolutions 242 and 338 has long been clear. First, there must be an agreement on the borders of the two states based on the June 1967 lines with equivalent land swaps between the parties. Second, security arrangements for the Palestinians must respect their sovereignty, and for Israel they must protect its security. Third, a just, fair, agreed and realistic solution to the refugee question must be put in place. And fourth, the aspirations of both parties for Jerusalem must be fulfilled through negotiations on the status of Jerusalem as the future capital of both states. The United Kingdom agrees with those states that urge the court not to cause prejudice to the existing Security Council framework or to decide any aspect of the parties' bilateral dispute. Like other participants, the United Kingdom recognises that an alternative route to respect propriety is to reinterpret the request or reformulate its terms. There is no question that the court has the power to proceed in this way. It has often been required to interpret or even reformulate the questions put. As Judge Tomka has acknowledged, the court can avoid intruding on a bilateral dispute by narrowing the scope of its answer. The question for the court is how best to achieve these aims. We propose that the court's opinion should focus on endorsing the continued application of the agreed framework with a view to ensuring its urgent implementation. An answer of this kind would respect the three propriety limitations that we have identified. It would also assist the General Assembly to discharge its mandate on the Palestinian question, which many participants have emphasised is the object of this request. More specifically, the United Kingdom, in this alternative submission, respectfully invites the court to do the following: to endorse the continued application of the Security Council framework to both parties and the need for its urgent implementation at the earliest possible opportunity, to recall both parties' obligations to respect the terms of the Council's framework, to recall both parties' agreement not to aggravate their dispute by taking any step to change the status or integrity of the occupied territories until a negotiated solution is agreed. And lastly, to reaffirm the parties' obligations in their interim agreements that they negotiate on permanent status issues. In this way, the court could assist the General Assembly in achieving its stated objective, which is to support urgent progress towards a negotiated solution within the Security Council framework. The United Kingdom reiterates that a negotiated two-state solution is the only way in which the Israeli-Palestinian conflict will be resolved. Mr. President, honourable members of the Court, thank you for your attention. That concludes the United Kingdom's submissions.
I thank the delegation of the United Kingdom for its presentation. I invite the next participating delegation, Slovenia, to address the Court, and I call Mr. Helmut Hartmann to the podium.
Mr. President, members of the Court, it is an honor to appear before you and to do so as a co-agent of the Republic of Slovenia. In the name of the Republic, I wish to extend our congratulations to new members of the Court and to you, Mr. President and Madam Vice President, for your elections. Slovenia has the highest respect for this Court and its important mission to ensure respect for international law on which it is the organ. By its Resolution 77-247 of 30 December 2022, the General Assembly has submitted to the scrutiny of the Court legal questions of fundamental importance for the United Nations and for the international community as a whole. The Republic of Slovenia supported the resolution and the request for an advisory opinion. We are convinced that the advisory opinion of the principal judicial organ will assist the General Assembly and all organs of the United Nations in their efforts and activities concerning the situation in Palestine. As it has been reiterated repeatedly, the United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In its declaration of the current situation in Palestine and Israel, adopted on 23 November last year, the National Assembly of the Republic of Slovenia expressed its hope that the international community, including the United Nations, adopts a more ambitious, responsible and coordinated approach that will constructively support the Middle East peace process, leading to a lasting, peaceful coexistence between two peoples and to a two-state solution. Mr. President, it's hardly need to recall in this great hall of justice that one of the purposes of the United Nations is to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlements of international disputes or situations which might lead to a breach of the peace. International law and its respect constitute the cornerstone of the activities of the organization and of the relations between its member states. As the principal judicial organ of the United Nations, this court's role is to identify existing principles and rules, interpret them and apply them, thus offering a reply to the question arising by the organs of the organization based on law. The questions submitted to your scrutiny concerning the legal consequences arising from policies and practices of Israel are scarcely susceptible of a reply otherwise than on the basis of law. The legal principles and rules upon which the court is asked to provide an advisory opinion constitute some of the most basic foundations for a peaceful, just, lasting and comprehensive solution to the question of Palestine. The Republic of Slovenia is fully committed to these fundamental principles, ensuring a consolidated multilateral system based on an effective United Nations organization, the sovereign equality of states, collective security, the peaceful settlement of disputes, the self-determination of peoples, high human rights standards, and a powerful rule of international law. We are mindful that a comprehensive solution needs to be achieved through meaningful negotiations aimed at the complete end of the occupation of the Palestinian territory and a resolution of all status issues. It is deeply concerning that despite efforts of the United Nations and the numerous resolutions of the General Assembly and the Security Council, negotiations have been stalled. As we speak, the prospect of the mutual agreed solution seems to be more and more uncertain. The situation in the region is alarming. Therefore, more than ever, it is indispensable for the organization and for the international community to take and to encourage all efforts that, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of the Palestinian state existing side by side with Israel and its other neighbors, with peace and security for all in the region, as the court emphasized in its 2004 advisory opinion. The Republic of Slovenia, through the voice of its National Assembly, reaffirmed its unwavering support for a negotiated two-state solution on the basis of the 1967 borders, resulting in two sovereign democratic states living together in peace and security in full respect of international law. However, Mr. President, the need for negotiations aimed at the mutual agreeable solution or the existence of the framework for such negotiations are not compelling reasons that should lead the Court to decline the request for an advisory opinion. On the contrary, further clarifications in respect of relevant legal principles, rules and responsibilities can only contribute to a solution on the basis of meaningful negotiations, international law and the rule of law. The Court recalled in 1996 and 2004 that it is, and I quote, aware that no matter what might be its conclusion in any opinion it might give, they would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element in the negotiations on the matter. End of quotation. In this regard, the questions asked by the General Assembly are relevant and have a practical effect guiding the United Nations, its member states, and those most directly involved in respect of the legal implications that need to be taken into account for achieving a lasting, comprehensive and just solution through peaceful means, and particularly through negotiations, is plenty part of the Court's judicial function. As a court of law, as a world court, you are entitled to pronounce on legal questions that will and must drive, frame and facilitate further actions and negotiations aimed at a full and complete settlement of the questions of Palestine. Mr. President, the Republic of Slovenia considers that nothing prevents the Court to address the request of the General Assembly in law and in fact. As I have already recalled, the questions are legal ones. The Court is asked to opine upon the legal consequences arising from policies and practices of Israel. It is thus for the Court to assess whether these policies and practices are in breach of rules and principles of international law, and on this basis clarify the legal consequences of these violations. Moreover, the record before the Court and the information publicly available contains sufficient information and evidence enabling the Court of properly assessing the questions of fact that are relevant and necessary for answering the legal questions before it. Mr. President, members of the Court, I thank you for your attention. Mr. President, may I kindly ask to give the floor to Dr. Daniel, who will continue the presentation of the Republic of Slovenia.
I thank Mr. Hartman.
So I now invite Dr. Daniel Müller to the podium. You have the floor, sir. Yes, thanks very much. Mr. President, distinguished members of the Court, it's a great privilege for me to appear before you and to do so to assist the Republic of Slovenia. Given the time at my disposal, it's scarcely conceivable to respond to all the aspects of the two questions addressed by the General Assembly in its Resolution 77247, so I'm going to stick to 2 points. First, the relevant rules and principles of international law to respond to the questions posed, and inter alia those relating to the right of the Palestinian people to self-determination. Then, secondly, I'll look at the legal consequences arising from the violations of these rules and principles of international law, inter alia for Israel, but perhaps for all the other states and for the United Nations. I'll do with these 2 points seriatim. Mr. President, the right of the Palestinian people of self-determination, specifically mentioned in the first question posed by the General Assembly, is not open to dispute. Your Court has already underscored in your advisory opinion of 2004 that the existence of a Palestinian people is no longer an issue, and that among the legitimate rights of the Palestinian people is that of self-determination. A people's right to self-determination is not just some random right, Indeed, as of 1945, the importance of this right has justified its inclusion in the Charter among the objectives of the organisation and side by side with the principle of the equal rights of peoples. The General Assembly subsequently confirmed in 1960 that, I quote, all peoples have the right to self-determination and that the subjection of peoples to alien subjugation, domination and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to the promotion of world peace and cooperation. The two covenants that Israel signed as of 1966 and to which it's a party since 1992 also reaffirm that all peoples have the right of self-determination and thus may freely determine their political status and freely pursue their economic, social and cultural development. So the right of peoples, of all peoples, to self-determination is not only one of the essential principles of contemporary international law, it is also a fundamental human right having a broad scope of application. Your court has recognized that the obligations arising from this essential right are erga omnes obligations. Now, as the co-agent has recalled, the Republic of Slovenia is particularly committed to this right. The people of Slovenia were able to exercise it in circumstances which the court will know well, in order to freely establish its own sovereign and independent state. Given its history, the Republic of Slovenia is persuaded that the right to self-determination is an essential and indispensable pillar of the international legal order. More recently, Slovenia has supported the incorporation by the International Law Commission of a non-exhaustive list of peremptory norms in its draft conclusions of 2022. And this list includes, as you well know, the right to self-determination. Now, to this day, the Palestinian people has been unable to fully exercise its inalienable right to self-determination. Indeed, Israel, the occupying power for many decades, is actively preventing the full realization of the Palestinians' right to self-determination in compliance with the guarantees and principles of international law. The occupation of Palestinian territory, its colonization and its fragmentation constitute not only a flagrant violation of the prohibition of the acquisition of territory by force, but also is a considerable impediment to the realization of a free and independent Palestinian state. The court recalled quite rightly that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. As a consequence thereof, any modification of the territorial base to which a people is entitled by right of self-determination, as well as the de facto and de jure annexation by Israel of a considerable part of Palestinian territory, are by their very nature contrary to international law. The need for respect and preservation of the territorial unity, contiguity and integrity of all of the occupied Palestinian territory, including East Jerusalem, recalled once again by the General Assembly in December last year, constitutes an essential condition for the Palestinian people to fully realize its right to self-determination and exercise its sovereignty over its territory. Thus, as the Council for Human Rights has recalled, the Israeli settlements fragmenting the West Bank, including East Jerusalem, into isolated geographical units, severely undermines the exercise of Palestinian self-determination. Mr. President, the right of the Palestinian people to self-determination is fundamentally hobbled by the prolonged occupation of Palestinian territory by the occupying power. and by the non-compliance with the obligations incumbent upon that power under the elementary rules of international humanitarian law. Palestinian territory remains under occupation within the meaning of international humanitarian law. The Court established in its advisory opinion 2004 that on account of this de facto situation, the relevant customary and conventional rules of international humanitarian law are applicable in occupied Palestinian territory, including East Jerusalem. So, international occupation law is based on the idea that occupation may only be a temporary and provisional situation. The occupying power does not acquire sovereignty over the territory it occupies and must administer it, taking due account of its specific legal status. It must abstain from taking measures likely to entail permanent change, be they the extent of the territory occupied or to its social, economic and demographic reality. More generally, the occupying power must not exercise its authority in order to promote its own interests, or with the aim of using the inhabitants, their property, or the resources of the occupied territory for its own benefit. The occupying power must ensure the protection of the population subject to occupation and take the necessary measures in order to respect their rights and ensure their implementation. Above all, that includes the fundamental rights guaranteeing dignity, equality, and the value of the individual. Rightly, the Court confirmed in 2004 that the treaty instruments relative to human rights remained applicable in OPT, and thus must be respected vis-à-vis the men, women, and children of Palestine. The practices and policies implemented by the occupying power in occupied Palestinian territory do not comply with the elementary obligations of international human rights law or international humanitarian law. The Court already confirmed this in 2004 with respect to the construction of the wall. However, the colonization of occupied Palestinian territory, including East Jerusalem, and the installation of settlements with the aim of achieving lasting demographic change, and the displacement of Palestinians, the destruction of their houses and their property, have but accelerated. The Court, the General Assembly, and the Security Council have recalled that settlements in occupied Palestinian territory have no legal basis and remain illegal. The Council vigorously regretted for a long time the continuation and persistence of Israel in pursuing those policies and practices. The written and oral statements of participants in the instant advisory proceedings have also demonstrated that the practices and policies of the occupying power are not consistent with what is required of it under international law. All these violations of international law arising from the prolonged occupation compromises the effective exercise by the Palestinian people for its right to self-determination and the achievement of a two-state solution, to which the Republic of Slovenia remains profoundly committed. Distinguished members of the Court, every internationally wrongful act of a state entails the international responsibility of that state. That key provision of the Articles on State Responsibility for Internationally Wrongful Acts contains in itself a part, an important part indeed, of the answer to the question of the legal consequences of the policies and practices which are before you. Israel has engaged its international responsibility. The content of the international responsibility of the State of Israel, or to use the terms of the ILC, the legal consequences involved by this responsibility, are enumerated in Articles 29 through 32 of the Articles on State Responsibility. Israel has the obligation to put an end to its internationally wrongful acts and to all the practices preventing the Palestinian people from fully exercising its right to self-determination, first and foremost of which are the prolonged occupation and annexation of Palestinian territory. Israel must fully carry out its international obligations, in particular its obligation to respect and promote the self-determination of the Palestinian people in the full compliance with international law. The harm caused by these internationally wrongful acts must be fully repaired. Implementation and compliance with these applications arising from the wrongful acts are not only due to Palestine and to the Palestinian people. On account of the erga omnes nature of the rules and obligations breached, which rules are due to the international community as a whole, any state, without distinction, is entitled to invoke Israel's responsibility. Any state can require the cessation of violations and compliance with the obligations in question. Any state is entitled to require the implementation of the obligation of reparation in the interest of the Palestinian people and the state of Palestine. As the court recalled in the Barcelona Traction case, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. Mr. President, as far as states other than Israel are concerned, and doubtless the United Nations too as an international organization, this isn't merely about summoning Israel to cease its wrongful acts. States do not only have a legally protected interest that Israel respects the right of the Palestinian people to self-determination. All states also have the duty, and the duty is to promote, through joint and separate action, realization of the principle of equal rights and self-determination of peoples in accordance with the provisions of the Charter, and to render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle. And that is rehearsing, you will have noted, the terms of Resolution 2625 for the General Assembly. In the same fashion, under the terms of Article 1, which is shared in all the 4 Geneva Conventions, the contracting states not only committed to respect the obligations arising from these treaties, but also to ensure respect of these obligations in all circumstances. The practices and policies impeding the realization of the right to self-determination of the Palestinian people cannot exempt the other states and the United Nations from these obligations. On the contrary, in the presence of the illegality of these practices and policies noted time and again by the principal organs of the United Nations, including your court, we must be able to count on the members of the United Nations to draw all attendant consequences and to implement the obligations falling to them pursuant to the Charter and international law. So that would imply for all states and for the United Nations to take the necessary measures to put an end to the tragic and above all illegal situation facing the Palestinian people, and which has faced them over decades. The General Assembly has recalled time and again and has urged all states and the specialized agencies and organizations of the UN system to continue to support and assist the Palestinian people in the early realization of their right to self-determination, independence and freedom. Furthermore, on account of the nature of the obligations in issue and their importance, states are not only held to cooperate to bring an end through lawful means these serious breaches, they are also under the obligation to not recognize the situation created by these breaches and must abstain from rendering any aid or assistance in maintaining this situation. The Court has already confirmed the relevance and existence of legal consequences for all states in its 2004 advisory opinion, and the General Assembly has requested all states members of the United Nations to comply with their legal obligations as mentioned in the advisory opinion, including those consistent with their obligations under international law and the relevant resolutions not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, and to not aid them in this end. In order to comply with these obligations, all states must inter alia distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. As the Security Council recalled in its Resolution 2334 of 2016, referring all the while to your advisory opinion. Mr. President, distinguished members of the Court, the painting by Paul Albert Besnard, which hangs in this great hall, recalls the cardinal principle of contemporary legal order: peace by justice. The Republic of Slovenia is firmly convinced that the scrupulous respect of international law, where the court is the principal judicial organ, can put an end to the unbearable and unacceptable situation in the region and work for a just and lasting peace in which every state in the area can live in security. Mr. President, these words close the oral presentation of the Republic of Slovenia, and on behalf of our delegation, I would like to thank you for your kind attention.
I thank the delegation of Slovenia for its presentation. I invite the next participating delegation, Sudan, to make its oral statement before the court and call upon Mr. Marwan Khair to take the floor.
Mr. President, distinguished members of the Court, it's my honor and privilege to address the International Court of Justice on behalf of the Republic of the Sudan. I express gratitude to this Court for extending the opportunity for my country's participation in these advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The Sudan is present here today, owing to the profound significance of these proceedings in the context of realizing the inalienable right of the Palestinian people to self-determination. This matter has persisted on the United Nations agenda for several decades. The dire circumstances prevailing in the occupied Palestinian territory over the past decades, compounded by the current severe humanitarian crisis in Gaza Strip, underscore the profound jeopardy facing the fundamental rights of all people in the Middle East, particularly the Palestinians. Therefore, these oral proceedings assume critical importance in persuading the Court to exercise its jurisdiction and accept this request for an advisory opinion. The Sudan contains that such a stand by the principal judicial organ of the United Nations would convey a definitive message to both Israel and Palestine, urging them to redouble their efforts in achieving peace and security for the mutual benefit for their peoples. Moreover, the Sudan maintained the perspective that in giving this advisory opinion, the Court would assume a crucial role in fostering justice, peace, and security, not only in Israel and Palestine, but also in the Middle East and beyond. Mr. President, in accordance with the rules of court, we will address the statement specifically to the issue that, from the perspective of the Sudan, remains a point of contention among the participants in these proceedings, whether or not the court should give the requested advisory opinion. The statement will be as succinct as possible within the limits of what is necessary for adequate presentation of the Sudan's contention at this hearing. Mr. President, I respectfully invite you to give the floor to Professor Raimondo, who will proceed with the delivery of this oral statement. Thank you, members of the court.
I thank Mr. Khair. I now give the floor to Mr. Fabian Raimondo. You have the floor, sir.
Mr. President, distinguished members of the court, it is my privilege and pleasure to stand before the International Court of Justice today to address the issues of jurisdiction and admissibility of this request for an advisory opinion. The articulation of objections to the admissibility of a request for an advisory opinion from the General Assembly is not an uncommon occurrence in proceedings before this court. Nevertheless, the court has consistently dismissed such objections. In the subsequent discussion, I shall initially recall the consistent jurisprudence of this court on the issues of jurisdiction and admissibility. It is within this body of jurisprudence that the court can find the resolution to the objections raised concerning the admissibility of the current request for an advisory opinion. As pointed out by this court in the Chagos advisory opinion, I quote, "When the court is seized of a request for an advisory opinion, it must first consider whether it has jurisdiction to give the opinion requested, and, if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request." Unquote. The jurisdiction of this court to provide an advisory opinion stems from Article 65, paragraph 1 of its statute. This article provides that the court may give an advisory opinion on any legal question upon the request of any body authorized by or in accordance with the Charter of the United Nations to make such a request. The General Assembly has the authority to request an advisory opinion according to Article 96, paragraph 1 of the Charter of the United Nations, and this article stipulates that the General Assembly has the power to ask the International Court of Justice to provide an advisory opinion on any legal question. In these proceedings, the court is first asked to determine the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Next, the Court is asked how said policies and practices affect the legal status of the occupation and what legal consequences ensue for all states and the United Nations from this status. Mr. President, members of the Court, it is evident that these questions concern the legal consequences of violations of international law that have been recognized as such by the Security Council and the General Assembly, among other United Nations organs and bodies, as well as to the legal status of the occupation in view of those violations and the legal consequences of its illegality. The General Assembly requests the Court to answer these questions in accordance with, inter alia, the rules and principles of international law, international humanitarian law, and international human rights law. For these reasons, the Sudan believes that the request has been made in accordance with the Charter and that the questions submitted to the Court are legal in character. I shall now proceed to the issue of the admissibility of the request. As recalled by the Court in the Chagos advisory opinion, I quote, "The fact that the Court has jurisdiction does not mean, however, that it is obliged to exercise it," unquote. According to consistent jurisprudence of this Court, the discretion whether or not to respond to a request for an advisory opinion exists to safeguard the judicial function of the Court as the principal judicial organ of the United Nations. However, the Court is aware that its reply to a request, I quote, represents its participation in the organization and, in principle, should not be reviewed, end of quote. It is an established jurisprudential principle that this Court may decline to respond to a request for an advisory opinion falling within its jurisdiction only in the presence of compelling reasons. The pertinent query at hand is whether there exists any compelling reason for this Court to decline to respond to the request referred by the General Assembly. Some participants in these proceedings have indeed alleged the existence of such reasons. The grounds most frequently invoked in these proceedings include, firstly, the contention that providing the opinion would prejudice the negotiation process between the parties involved in the underlying dispute. Secondly, the argument that admitting the request will be incompatible with the principle of consent in judicial settlement. And thirdly, the alleged prejudicial nature of the underlying questions and the lack of sufficient factual inquiry. I will now examine the first ground. This ground was raised by Canada, Hungary, Israel, Italy, and Zambia, among others. Thus, for example, in the opinion of Italy, I quote, "An advisory opinion by the court might reduce the flexibility of the parties in dealing with present circumstances and long-term prospects, and therefore would not contribute to move the process closer to a mutually agreed solution." End of quote. This constitutes a type of argument that this court has previously considered in other advisory proceedings. For example, in the nuclear weapons advisory opinion, the court noted that concerns were raised about the potential negative impact of its response on disarmament negotiations. The court acknowledged that regardless of its conclusions, they would introduce an additional aspect to the negotiations. However, the court stated that the ultimate effect of its opinion is a matter of appreciation and cannot be seen as a compelling reason to refuse exercising its jurisdiction. This jurisprudential principle was confirmed by this court in the advisory opinion on the wall. There is an additional, pivotal aspect to address in this context. The two questions central to the ongoing advisory proceedings pertain to the existing conditions in the occupied Palestinian territory. The court is not tasked with determining the content of a final settlement or the precise boundaries of the Palestinian state. Essentially, the request seeks the court to provide an authoritative legal opinion on the current legal ramifications of the practices and policies of Israel referred to in the request. The advisory opinion is expected to bear relevance to extant queries regarding legal status and its associated consequences. Such clarification holds the potential to significantly contribute to establishing the groundwork for a prospective negotiated resolution of the underlying conflict, rather than to endanger the established framework for negotiations that have been suspended for several years now. Hence, the Sudan believes that this does not constitute a compelling reason to decline responding to the request. I shall now address the second ground, the contention that the opinion would circumvent the principle of consent in judicial settlement. This ground was raised by Canada, Fiji, Hungary, Israel, and the United Kingdom, among other participants. For example, Canada objects that, I quote, "It is Canada's understanding that Israel, which has a direct interest in this case, has not provided consent for the ICJ to desist of this matter." End of quote. It is well-established jurisprudence of this court that the lack of consent to the court's contentious jurisdiction by interested states does not impact the court's jurisdiction to render an advisory opinion. This rationale is exemplified by instances such as when the court gave its advisory opinion on Western Sahara, even in the absence of Spain's consent to the request. When it delivered the advisory opinion on the wall, despite Israel not providing consent. And when it issued the Chagos advisory opinion, notwithstanding the absence of consent from the United Kingdom. In each of these instances, the court gave its opinions, even though the request concerned the responsibility of particular states. As this court said in Western Sahara, I quote, "In the present case, Spain is a member of the United Nations and has accepted the provisions of the Charter and Statute. It has thereby, in general, given its consent to the exercise by the court of its advisory jurisdiction." Unquote. In the Sudan's view, the same rationale applies in the current advisory proceedings. The General Assembly has consistently played a crucial role in matters concerning Palestine, as evident from the documentation presented in the Secretary General's dossier before this court. The Palestinian people are yet to realize their right to self-determination, a fact that no state can plausibly contest. Therefore, the Sudan believes that the objection to the General Assembly's exercise of its competence in the realm of self-determination and its consideration of the situation in Palestine is unpersuasive. I shall now address the final ground, the allegedly prejudicial nature of the questions posed by the General Assembly and the lack of appropriate factual inquiry. This ground was raised by Israel in the following terms, I quote, "The tendentious questions placed before the court not only distort the factual reality, they fundamentally misrepresent the legal reality as well." End of quote. In the same vein, another participant in the proceedings, the United Kingdom, posits that the request is inadmissible on the ground that, I quote, "the court cannot be confident that it will have a complete or accurate evidential picture before it." End of quote. Further, in this regard, the United Kingdom contends that, I quote again, "insofar as Israel does not participate in the advisory proceedings by furnishing evidence relevant to the request, the court will lack material explaining the Israeli side of the picture." End of quote. Nevertheless, it is imperative to recall that in the overwhelming majority, if not all, of the opinions rendered by this court, reliance on public information derived, for instance, from United Nations organs or specialized agencies has been a standard practice. In part 2 of the dossier of materials before this court, there are many reports of competent United Nations bodies, such as the Special Rapporteur on the Situation of Human Rights in the OPT, the High Commissioner for Human Rights, and several human rights treaty bodies. Hence, in the Sudan's view, all these reports provide the court with sufficient information on the facts before it to give the requested opinion. Mr. President, members of the court, I express my gratitude for your attentive consideration, and I respectfully invite you to request Mr. Khair to deliver the concluding remarks of the oral statement on behalf of the Sudan.
I thank Mr. Raimondo. I now give the floor back to Mr. Khair. You have the floor, sir.
Mr. President, distinguished members of the court, I wish to emphasize the great significance of the right of peoples to self-determination. In advisory proceedings conducted before this court, wherein the exercise of this right was a pivotal concern, the court's opinion emerged out of fundamental elements shaping the legal framework for resolving the underlying disputes, such as the one concerning Namibia. If only we had a comparable equivalent for Palestine. The successful resolution of the protracted dispute surrounding Namibia can be largely attributed to the court's judicial task. It's respectfully suggested that you should persist in fulfilling that role in the present advisory proceedings. In the light of the foregoing, the Sudan concludes that the court not only has jurisdiction to give the advisory opinion requested by the General Assembly, but also that there is no compelling reason for this court to use its discretionary power not to give the opinion. Thank you, Mr. President. Thank you, members of the court.
I thank the delegation of Sudan for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.